Thank you very much. Good afternoon. I'm just going to start from here, but don't worry, it is going to be a panel discussion. My name is Paul Strelitz. As you've heard, we've got a bit of a stellar panel this afternoon to discuss compulsory arbitration, compulsory mediation, compulsory ADR, whatever you may want to call it, or indeed dropping one of those letters from the acronym, as we'll hear about in a moment. Just before we do, just to get an idea, because we're going to do this at the start and at the end, for those of you who want to, and I know it's the post-lunch slump, but for those of you who want to, those of you in here who are in favour of, in commercial cases, introducing compulsory alternative dispute resolution, forget the A for one moment, compulsory dispute resolution outside of the normal trial process, those of you who are in favour of it, or who think you're in favour of it at the moment, could you put your hand up, please, so we can get a rough idea? A quarter? About a quarter. All right, thank you very much. Don't worry, no more audience participation required. Right, 12th of July, 2021. You may remember that period of time, some of you, because you'll no doubt have all been sat at home ripped with excitement because it was about a week before what the Red Tops called Freedom Day. Well, something else equally exciting happened, if you're a lawyer, and that was that the Civil Justice Council, led by Lady Justice Asplin, delivered their report on compulsory alternative dispute resolution on the 12th of July this year. It concludes that mandatory alternative dispute resolution is compatible with Article 6 of the European Human Rights Convention and therefore lawful. In a comment, which some of you may think is telling, the Master of the Role, Sir Geoffrey Voss, said this, and this is his published comment. As I have said before, ADR should no longer be viewed as alternative, but as an integral part of the dispute resolution process, which may give you a flavour as to what the Master of the Roles was thinking. In terms of the background to the report, just because it informs the discussion that we're about to have now, most of you, I'm sure, will be aware that the leading case on compelling a form of dispute resolution is Halsey and Milton Keynes, but that's from 2004, so a little bit historic now. But in that case, Lord Justice Dyson concluded it was not lawful to compel parties to mediate, and he went further. He even added that even if he was wrong about that, because Lord Justice Dyson likes, and even if I'm wrong about this, he said, the list of cases that would ever be appropriate to be sent for ADR was vanishingly small. He added the court's role is to encourage, not to compel. Well, fast forward to Lady Justice Asplin's report in July of this year. As the report notes, the rules of the civil procedure in England and Wales have already developed into areas where they provide for compulsory participation in ADR at a number of points, some of which Lady Justice Asplin says are successful. You may hear from the panel or from yourselves later on that there may be some competing views on that. The conclusion was that it was compatible to compel what might be called extrajudicial dispute resolution, although that term is misleading because, of course, one form of alternative dispute resolution could involve judge-led mediation. Lady Justice Asplin said this was subject to a number of factors. Those factors really form the basis of our discussion, and no doubt the discussions at your water coolers, and indeed when this is introduced, because as far as I'm concerned, Sir Geoffrey Voss has told us it is going to be introduced, how it's then played out in terms of practice. These are obvious, it seems to me: cost, time burden on parties, whether the process is particularly suitable in certain specialist areas, the importance of confidence in the ADR provider, the stage of proceedings which ADR may be required, and whether the terms of obligation to participate are sufficiently clear. Thus, whilst we are at the moment in a position whereby we know it's coming, of course, none of us know what it will look like. What we can be confident of, though, in addition to it coming, is that they're going to try and put a boot in. Because in the report, so central to the litigation process will it be that Lady Justice Asplin said sanctions will likely follow for non-compliance. That may even involve striking out a claim or a defence as a result of a failure to comply with that mandatory requirement, which you may see at paragraph 11. So people are going to have a particular eye on whether or not there has been compliance, whether this be in the term of an order, if it's a standard order, or indeed as part of our civil procedure rules. Now, the list of areas that it will impact are too numerous to mention, but here with me today we've got a stellar panel, so I'm going to go over there now and we're going to have a discussion. Starting first with Robert, As you heard, Robert from RPC, he's a partner at RPC, focuses on tax disputes, public and administrative law, and cross-border regulatory investigations. Now, Robert, your practice has a tax disputes focus. I understand that there's already a form of ADR in that arena. Can you maybe explain a little bit to us about how that's working and whether you think it might be a good platform to move forwards?
Yeah, thanks very much. I think the first question for most people is, what on earth is this person doing here as a tax litigator? The idea is that I look at one of the niche areas where ADR is already being used, although it's not yet compulsory in the tax world. And from that, hopefully, we will get some idea of some of the ways in which it works and some of the ways it doesn't work. I think it would be fair to say, and there'll be further comments on this, I'm sure, that in the report it's a little bit light on detail when you get down to exactly what this is going to look like. And looking at it from the sharp end of ADR in the context of disputes against a government department, I can assure you that there are a few areas for improvement. So back in 2013, the Revenue introduced a new system of alternative dispute resolution. It's not compulsory, as I say. And the circumstances are that the taxpayer can apply at any stage to enter into ADR with HMRC. HMRC then takes that application and they decide whether or not it is a case which is amenable to ADR, and both parties effectively have to agree. It says at any stage, but usually the case has to be at a sufficiently advanced state for you to understand roughly what the Revenue's arguments are in a particular tax treatment. So that's usually at the end of an inquiry, sometimes at the point at which you've already got into the statutory tribunal system. For those who don't know, most tax disputes are decided through a statutory appeals system, which is similar to the world of employment, for instance. There are other circumstances, of course, public law, etc., where you can end up in other forum. And the Revenue has flip-flopped a little bit over time over precisely the point at which they agree to ADR. So there was a brief period where they wouldn't accept ADR if, for instance, they'd issued a statement of case. But they've now resolved from that on the basis that, to be honest, in a lot of tax disputes, that's the first time you work out what their arguments are in the first place. They also exclude various categories, and that's when I think it starts to get quite interesting from the point of view of this discussion. So, for instance, you can't have an ADR involving the Revenue where you have circumstances where there's some kind of criminal activity which is being alleged or dishonesty. In cases involving public law, they don't put it this way, but broadly speaking, where you're dealing with some sort of discretion, or legitimate expectation, those sorts of things, the Revenue won't permit those to go into an ADR discussion. Also, in circumstances where you have unusual, I know, but if you have a complaint against a particular officer, this isn't the forum in which you can render that complaint. And also in penalty cases, they exclude it. Usually on the other side, you've got the officer who's been handling the case, so you've got effectively the person who's seen it from the start. And one of the key sticking points, I think, certainly from the point of view of most of you in this room, will be the way in which the Revenue has set up this system is that the mediator who is appointed is a Revenue mediator, described as an independent HMRC mediator, which I think from the ripples of laughter in the room would strike most of you as a bit odd, at the least. There are circumstances where you can have an additional mediator appointed with the agreement of HMRC, but usually that doesn't happen because of the cost implications. So we've got a system which has been being developed over the last 8 or 9 years, and the Revenue has really tinkered around with the way in which it works. So the issues that start to arise in this context are what the nature of the agreement is that you get at the end of it. So this is quite a recent development. The Revenue finds it very difficult, in particular, to come up with a system where they can have binding agreements at the end. The reason for this is because of the statutory nature of the powers which officers have, and they get very worried about the extent to which they are actually capable of agreeing to certain settlements. The problem, of course, that produces for anybody who wants to embark upon any kind of ADR or mediation is that the whole thing can become rendered pointless if at the end of the day they're not prepared to agree to anything. The other problem that you can encounter, particularly in relation to government departments, is that you don't have the right person in the room. So you're dealing against the officer in the context of a particular tax debate. You have your discussion with your Revenue mediator. Everybody agrees on a particular outcome. The officer then walks away, tells the people at 100 Parliament Street who sit in policy what they've just agreed to. and 2 days later you get a letter saying, very sorry, but we can't sign this. That's happened a number of times.
And when in the process does it happen in the tax world? When in the litigation process does this mediation take place?
So it can happen pre-litigation. In other words, it can happen before the revenue is issued and its assessment, in whatever guise that takes. And obviously, in the tax context, you then appeal that assessment. So that's effectively your first decision. It can happen before that. Particularly useful if you've got really intransigent, locked up position between parties. You want to have a debate about the factual issues, so some kind of misunderstanding. That's quite useful. More often than not, though, you will have got through to the appeal stage, and it will be before the tribunal. And at that point, you then make your application to move to ADR. And
in terms of adding to the overall cost in the tax world, what's your experience in that way?
Well, I mean, the same reasons which are put forward in the report for why ADR is a good idea. With a couple of additional ones are broadly the same. The idea is that it's cheaper, quicker, cuts to the chase, and you don't have the litigation risk.
And is it?
My experience is if you've got a case which involves a dispute on fact or a misunderstanding, ADR can be a really good way of cutting through that and getting, banging some heads together in the context of getting two people in the same room. But as soon as you get any level of legal complexity, or policy significance. So, a particular point might have, as I mentioned earlier, there could be an entire department within policy section that is interested in this particular treatment of this particular tax. Really, I think it's hopeless. It doesn't work.
Yeah. So, Sarah, I understand that you've got a couple of anecdotes, perhaps, or areas of experience in other areas where there might have been compulsory forms of dispute resolution in your firm. What's your experience there?
Yeah, I haven't personally, but I checked with my firm on what the Civil Justice Council's report said were really effective ways of starting compulsory ADR. The first is the MIAM, which, as I said to the guys on the panel, sounds like a bag of sweets, but is in fact a compulsory step in family proceedings now before you can issue. Well, that is applicant only. Respondents don't have to participate. That mediation is a 90-minute meeting. It costs 90 quid. You're not allowed a lawyer there. You haven't got any expert evidence there. And it is completely a tick box exercise that has now been put in, as far as my lawyers are concerned, just to get on with their case. If you look at ACAS and early conciliation in the context of employment disputes, very, very similar. You have to contact ACAS. You cannot start your tribunal claim unless you have. But the usefulness of ACAS is overstretched, under-resourced, and is ineffective. If you are the employee, particularly if you're not represented, if you're the employer, you just want to get on with it. So neither of those two processes particularly effective. I think the only area where I can see that some sort of judge intervening dispute resolution is reasonably effective is in the FDR hearings in matrimonial cases. That does seem, because they're giving a view, to impact on how people then move forward.
And what do you think sets that apart then? Why is that more effective than, for example, ACAS early conciliation or MIAM in family? What makes the FDR more effective?
Because both parties have to attend, and it is giving a view. And I certainly think that where there was discussions about E&E, that giving a view rather than forcing parties unwillingly to participate in an ADR is a better way, perhaps, to narrow the issues between the parties. That's just my personal view. And it's all about the timing and the cost of it that is determinative as to whether or not this is going to work.
Well, a couple of areas then where you may detect some pessimism that's ongoing elsewhere. So over to you, Luke, then, for $1 million question. Coming back into the commercial sphere at this litigation summit then, the new form of mandated dispute resolution in commercial litigation, what do we think it's going to look like?
Well, I should start by saying that I agree we should drop.
Just hold the mic.
Yeah, that's better. I should start by saying I think we should definitely drop the A from ADR. I think there needs to be a bit of a mindset change in the profession to dispute resolution being part of the process that runs and courses through the veins of the dispute from the beginning, and is not some stage in proceedings, which I think currently mediation, one of the most popular forms of ADR, is actually seen as. So I suppose it follows there that I don't think that compulsory ADR should involve mandatory ADR or DR before the commencement of proceedings. We talked a little bit about some of the box-ticking efforts that are happening in other areas, and I think it simply would become a box-ticking exercise and add to the cost. I did note that actually in other jurisdictions it has been adopted. Section 89 of the Indian Civil Procedure Code, for example, mandates it. So certainly other jurisdictions think this is the way forward, but I don't think that's what's going to happen over here. I think it's important to be mindful in the implementation of any compulsory DR to ensure that we keep Article 6 in mind, because I think there are still potentially areas where we could restrict access to justice, we could restrict that fundamental right to access the courts. And we've seen certain areas where forms of dispute resolution have been mandated. For example, in consumer contracts, sometimes arbitration is mandated, but there are statutes that override that. The Consumer Act 2015 will still allow a consumer to litigate something subject to a compulsory arbitration clause most of the time, if that arbitration clause itself would be unfair. And certainly that seems to be an approach in some European jurisdictions, notably in Spain, where similar legislation exists, and also where a form of alternative dispute resolution is going to be cost prohibitive. I think it's obviously going to be wrong to mandate it, because that could still have the practical impact of restricting access to justice and restricting access to the courts. So I suppose, in what guise do I think it will actually take? I think it will take the form of a practice direction, pursuant to which then there will be judicial guidance. I think CPR Part 3 already has CPR Part 3M, which is the express ability to order early neutral evaluation, and I can see some tinkering around CPR Part 3. But the most important thing to me, Paul, is that I think it needs to be kept flexible, because when it comes to resolving a dispute, each case does turn on its own merits. And we heard earlier from the panel talking about some of the over-tinkering that's been happening with case management. If you make things overly prescriptive, you end up people sort of jumping through hoops, and it doesn't actually achieve the aim that you want it to. So flexibility based on the facts of an individual case, I think, is important.
Interesting, isn't it, that the conclusion has been reached in the report that it is compatible with Article 6, but without actually saying what the regime will look like in order to work out whether or not there may be further barriers that you've just been alluding to. So why the practice direction then? Why in the form of a practice direction, not in the form of it being maybe within the procedural rules or indeed having legislative force?
Well, I think, as I said, CPR Part 3.1 is where I suspect there will be a permission to create an order. But I think what you need is some guidance, and the guidance generally finds its way into practice directions. And probably it's probably also worth mentioning my view on mediation, which might be somewhat controversial. I know there are a few mediators in
We
this
like
room.
controversy. Go on, Luke.
But I mean, I actually think mediation in its currently used form is a little outdated. I think what we need is, I'm going to call it DR 2.0 or mediation 2.0. But I don't think it's all doom and gloom for mediation practitioners, because I think they are the best breed of dispute resolution practitioners to reinvent themselves as DR 2.0 practitioners. And what do I mean by DR 2.0? I think compulsory dispute resolution in its ideal form will involve the parties appointing a dispute resolution professional independent from the parties' lawyers early on in the case to help the parties identify what the issues are that are in dispute, because believe it or not, sometimes we lawyers can't actually agree upon the issues that are in dispute, but also not just identify the issues that are in dispute for the purposes of the case, but also identify the principles behind those issues in dispute, which is equally important, and then just work with the parties' lawyers to devise a form of bespoke dispute resolution that is going to work in that case. And that may very well involve some aspects of the case being determined by early neutral evaluation. And I know, Sarah, you've had a lot of experience of E&E, but it may involve also some elements of the dispute being dealt with mediation, but after perhaps a roadblock has been cleared via E&E or something like that. So I think ultimately we're going to need to keep it flexible, but what we don't want to do is have a situation where you're forcing the parties to engage in a process that they don't want to and isn't going to be effective.
Well, interesting then, isn't it, that I think we all agree that there's going to have to be some degree of flexibility, but if there are to be these sanctions to be applied, and maybe we'll come back to this later on, how on earth are sanctions going to be applied as against a WP process, where indeed there is flexibility required because it's on a case-by-case analysis, but maybe we'll come back to that in a moment. As litigators, we're all, of course, tacticians. We're all supposed to be thinking at every given opportunity, whether that be at your desk or indeed grabbing a coffee, about your client's case and how you might advance it. Well, in terms of tactics, then, this is just presumably going to be another weapon in the arsenal of those who want to use it and use it properly. Stephen, what do you think about, from a tactical perspective, this might mean for the running of cases in the event that compulsory dispute resolution is introduced?
Well, I think parties using ADR as part of a wider case strategy is already happening. So I don't think there's going to be any radical change from how people will approach ADR, and all the various guises of ADR will remain the same. But the question for me would be, if it's mandatory ADR in each case, is that going to give us more of a fertile ground for people deploying these tactics? So I don't think the tactics necessarily going to change, subject to what might be in the PD and how the regime is actually implemented. It will depend very much, I think, on the different types of claim and how the parties and how the lawyers will engage with the new regime, whatever that might look like for the different claims. And the CJC report noted that any type of regime that's introduced is going to have to be carefully looked at and assessed as to what kind of claims that will apply to, and there might well be differences. So, for instance, you've got the smaller, lower value, repetitive claims, possibly that are online, whereby it's going to be much more of a light touch. It could just be like a prompt online that you have to make an offer or think about making an offer. In those scenarios, you can't see that there's going to be a huge amount of scope for tactics to be deployed, either do it or not, and there's not really any consequence of that. But if you're looking at the perhaps more complex, more higher value claims, then, as the report notes, and I think we would probably all agree that those types of claims are likely going to require a more involved, more engaged ADR process, maybe something similar to what Luke was just mentioning there. And it might be a mixed diet of what ADR is deployed, and that could be expensive, not just the legal costs, but in terms of the third party who's facilitating that process, in which case then there's more scope, I think, for tactics to be deployed in a similar way to what they are now, I think, in the landscape as we have it at the moment.
Will much of this depend upon timing? So what's your view then, Stephen, on the point at which this compulsory form of dispute resolution is mandated upon the parties, whether it's pre-issue, immediately post-issue, at some point before a trial window? Do you think timing will affect it at all?
I think it will. If it's pre-issue, then the court aren't overseeing that process. So if you've got any delay tactics, if a party wants to kick the can down the road, then you freely can do so, and it's up to the other party or if it's a claimant in that case, to issue proceedings. So, whereas if you're say post-issue, like it is now, you've got a period of stay, and there's a cut-off for that. So I think that's a factor. If it's pre-issue as well, then you might have the possibility of claimants with perhaps trying on a bit in terms of a claim, and the merits of the claim aren't a bit more dubious than perhaps some others, that the tactic of slinging a letter before action to try and force a smash and grab settlement by then saying let's do ADR now because you have to, it kind of cloaks that or blurs the edges in relation to that tactic. As a defendant, you might spot that straight away, but under that regime, you've just got to go to ADR. So the claimant gets what they want, you're in a room, and you might do a deal subject to how good the mediator is or the E&E judge.
And what about your experience as a commercial litigator there in terms of the judicial approach? So going in front of the judge, whether it's at the CCMC, CMC or some other hearing, and saying we'd like some time to mediate, we'd like to stay, or perhaps slightly more controversially, we'd like to start moving some directions around and maybe even jeopardise the timetable. What's your view on how judges have tended to receive it thus far when it's not been compulsory, and how might that inform what it might mean going forwards when they're being told they have to do it for the practice direction, if Luke's right?
In my experience, unless it's going to impinge on certain specific hurdles or directions that have to be met, especially prep for trial, etc., that the court is normally very amenable to you having some breathing space to actually pursue ADR by agreement. If it's mandatory, I don't think it will change the court's approach. They just have to do it because it's part of the rules. For me, timing. Going back to what you're saying earlier, I think timing is a big issue, and I don't know whether it's going to be pre-issue or post-issue. If it's post-issue, when is there going to be a backstop? Is it going to be something that has to be done before the CCMC? Is it bolted onto the CCMC? That will play into the tactics that are deployed, I'm sure.
Still on tactics then, Robert. Can you think of cases where this sounds like it might be starting to work, where you might be rubbing your hands together thinking, well, this is going to play into my client's hands, as opposed to other cases where you'll be thinking, well, this is going to be a disaster?
Well, I think that the obvious areas for it to be positive are situations. So I sometimes come across areas where confidentiality can be very important to a particular client. ADR gives them at least a route to try and agree at some kind of settlement, which keeps the matter away from the press. That can be something that can be very attractive. The downside with that is it's usually more important to one party than the other, so it can be used as leverage. I think in the context of, as I mentioned earlier, in the context of novel points, or particularly legal points of policy and so on, it's very difficult for these matters to be progressed through ADR. There are circumstances where the client wants to create delay, and that really plays into their hands, I'd suggest. I think a couple of points that have been picked up on it is the idea that this question of who does this process actually benefit? So who is it designed to, what is it designed to achieve, and beyond simply removing the number of cases that get dragged through the courts? And how do you get to that particular aim? And is that legitimate? So we've talked about, and the report talks about the different environments in which ADR is already compulsory. And Sarah's touched on a few of those. I don't think that the report, if I may say, is particularly fair about how successful those particular routes are at the moment. My overwhelming experience, or at least the experience that's been conveyed to me from people in other areas, is that they're generally pretty poor. Yet they seem to be held up in the report as being something which is successful, attractive, and so on. And why do those areas not work terribly well? I think they don't work terribly well because they're not terribly well funded. And I think this comes down to a kind of critical point which underlays the whole reform. It may well be the case that it's possible to make ADR work, and there's some other points that we can make in relation to how you can actually supercharge the process to make it work. But fundamentally, if the object of the exercise is simply to reduce the number of cases that are troubling the High Court, then it's probably not going to be successful. It will be something which will generate more costs. It's something that will be a process which will put people off. And inevitably what that means is it will put people off who've got the least resources. I think the way that you get around that in a system like this is by funding it properly, by putting in place people with sufficient experience and qualification in order to manage the process, so the mediators and so on who actually run the process, so that you can actually have a robust system. You can have a system where people are obliged to participate fully and properly, otherwise they face sanctions. In the report, you get to the section around sanctions. There isn't an awful lot there. It's a couple of paragraphs, really. And it points out this problem that people can give perfunctory compliance with directions. There might even be a few people in this room that have done that at one stage or another. And how on earth do you manage that? How do you get people to actually engage properly with the process? And if they don't, they face sanction. So I've sat there in ADRs against the revenue before, where you get the officer who's been holding onto a case for the last 3-4 years worth of inquiry, frankly dislikes my client, sits there with his arms folded, and he's there because he's been told to be there. There's no sanction for that officer. Our client's paid money to be in that room, either to their legal advisors or just in terms of the delay. And it's really, really important. If we're going to have a system, I think, that works, trying to look at it in a slightly more positive way than perhaps I did earlier, it has to be properly funded. It has to have people who have actually got the ability to get their arms around a dispute like this, from the point of view of the mediators, and can actually force the parties to participate in it properly. If we've already agreed that it doesn't breach any human rights rules, then they have to have the power to force them to participate.
And how might that be reported back, do you think? In the event that they're going to have the power to do something and they're not the judge who might be docketing the case, what are they going to have to do? Are they going to have to write a report to the judge to say who was naughty and who was nice?
Well, I struggle to see how else you could do it. I mean, I think that we're moving perhaps what I'm advocating here, if that is what I'm doing, but if we're going to be faced with this, as you suggest, from the Master of the Rolls, then there has to be some kind of mechanism where there can be some sort of reporting, because otherwise how on earth will you make the sanctions work? So that will require them to sit in actually a quasi-judicial role, if not only on that point. And then we're moving to a mediator role, which is perhaps more the sort of thing that you might see in America, where you've got usually either acting or former judges who will sit there and say, if this had been in my court, this is what I would have said, this is what I would have done. This is the way I would have found on this point. And that's not really our model over here at the moment, is it? It's very much a let's meet in the middle. I mean, that doesn't work in my world, meet in the middle, because tax is binary. So you either fit the exemption or you don't. You're either caught by the tax charge or you're not, which is why ADR is a strange thing in my world. But this sort of mediation, and so the tradition of mediation in this country is rather more about getting people to meet in the middle, isn't it? I think
where I think we're all probably agreed that it's going to be an extra stage, and therefore, of course, for those at least who have lawyers, it's going to be an extra cost. Sarah, I know that this is something that, from our prior discussions, you're quite passionate about then. What's this going to mean in real-world terms? Not necessarily for the X PLC versus Y PLC, but for the run-of-the-mill, still commercial, but lower-value cases.
I think it's going to cause major problems where there's an inequality in bargaining position, as it always has done. And justice is now seen as expensive and exclusive. And I love that as an expression, because it is. The upfront loading of costs we're all very well used to. It's worse than it ever was. Adding these extra steps in now, and I think, reading the report, they are likely to go for you can't issue until you've gone through some form of dispute resolution, albeit it might be online in some form of blind bidding, which I think is quite extraordinary. It's like an online auction, isn't it? But the difficulty that is going to occur is the party that is short of cash is going to be run out of money very quickly. And I think that's a real problem for our justice system. And tactically, if you're the party with the money, then you're going to deploy those tactics. And this perfunctory performance in the context of compulsory mediation is a massive problem that Robert alluded to. It's without prejudice on how on earth is anybody going to sanction anybody for just sitting there with their arms folded, as Robert referred to the HMRC officer. But in any dispute, we've all been in mediations where that's happened, where actually the tactic was something else. It was, I want to frighten them, I want to test what they're like as a witness, I want to do all sorts of different things. I'm not saying, of course, I've ever used any of those tactics, but it is that and the psychological impact that then has on probably the party that can't afford it. And this sort of socialist bit is just coming to the fore, really, in terms of what do we do with that? How do we deal with that? And I think it's going to be a real David and Goliath problem going forward.
It sounds like then it might be fraught with pitfalls. So, Luke, what do you think? Have we come full circle? Have we come back to the point where we've convinced ourselves that, in fact, a compulsory form of dispute resolution is a bad idea? Because if the parties really want to do it, they do it anyway. And, in fact, maybe Lord Justice Dyson got it right in 2004.
I'm still with compulsory mediation, so compulsory dispute resolution, possibly involving mediation. Dealing with the problem that we've just been discussing, I think there is a practical way which you could lift the lid on what happens in the dispute resolution process to make sure that the parties behave properly. And I think that is an important point. The parties have got to behave and got to properly engage with the process if it's to be effective. Otherwise, it is a tick box process. And that's that you could make the process without prejudice save as to costs rather than without prejudice, as it generally is. And you could, in theory, have an order that the dispute resolution practitioner, whether it be the mediator or somebody else who's been involved, has to provide a witness statement to the court in a sealed envelope or on CE file and a password-protected file or whatever, that essentially is opened after the end of the litigation and is admissible on the question of costs. I think that would really focus people's minds, because I have to say I agree with what Sarah and Stephen have said about the tactics, and I've been in many mediations over the years where we built up to the mediation day brilling with optimism as to the fact that we will hopefully be able to resolve the dispute for the client, and the defendants have had a very different game face on for the mediation. They've wanted to see the whites of the eyes of the witnesses, and they've wanted to smoke out the claimant and try and find out whether they really have got the fight in them.
But just playing that witness statement point out for a second, and I have to say in an area where I sit, I have seen a standard paragraph which says, in the event that a party alleges that the other has not entered into the mediation with good spirit, they are required to sign an affidavit, swear an affidavit. But how does that look? What's wrong with the party saying, well, we turned up and we offered what as the defendant in that case, we turned up and we offered what we thought it was worth? What's wrong with that? Why should we be sanctioned for that? What's wrong with it?
I don't think you can sanction people for not making offers sort of over a certain level, because people are perfectly entitled to make whatever offer they feel is commercially right. I think the area where people potentially should be sanctioned is where they're not properly participating in the process, because I don't think...
Sorry, what does that mean then?
Well,
if they've got, short of turning up, you've got to be there.
Yeah.
They turn up, they make an offer at the level that they think is appropriate for them. What does a sanction for failure to comply look like, do we think? Because I'm struggling to envisage a situation whereby it might then be sanctionable.
Yes, I mean, I think it will be difficult, and I think it would be very difficult to ultimately get to the point of saying you have simply not engaged with the dispute resolution process. But in scenarios where people have engaged in a mediation and have not been willing to discuss, for example, the other side's position on a particular point, or have not been willing to explore why it is they've adopted this particular principled stance on the issue, etc., which I think is really where you do make inroads into resolving a dispute. I think that sort of intransigence can and should be sanctioned. I do think that over the years, mediation has become this blind bidding type sort of situation, and I think the problem with that is it just isn't very effective to sit in the IDRC for 18 hours and get to the end and make offers at the last minute. And I think if the approach to dispute resolution changes and becomes much more about identifying the issues, working collaboratively to try and resolve those issues, then I think you can sanction people for not engaging in that process.
The timing one's an interesting one, isn't it? Because if it is to be mandated, there needs to be some sort of structure. It can't just be given over to judges and be told it is mandatory, but you do what you will. But if it is mandatory, how many times have any of you been to a mediation where they say, oh, well, we'd love to discuss that point with you, but in fact, we think there's more to come out in disclosure? If you're doing some of the cases that I do, where there are allegations of fraud, etc., going on behind the scenes, and we say, oh, we think extended disclosure is going to be terribly illuminating, and on that basis, we're not prepared to make offers at that level until after that point in time. Is that not also a potential pitfall if we have the rigidity of a practice direction, which says you've got to impose the stay then, or it is pre-issue, that the parties might still be deploying the same old arguments of, well, yeah, but we can't make that offer now? Stephen, what are your thoughts on that?
Totally agree. I think if you're going to have a pre-issue meeting...
Notice I went for the person who was nodding.
If you have pre-issue mandatory ADR, before the pleadings, do you know enough that you're going to be able to make informed... you're in a bit of a speculative bidding, as we've just mentioned, you can see that they will fail, and then perhaps you'll go to mediation later. I think it feeds into something that struck me when Luke was just talking then, in the context of having functionary performance, and whether there is as the report says, whether there's a cheaper, faster format for mediations for commercial disputes, so it makes it more affordable and proportionate. You could just get a two-tier ADR track, which is whereby if you get the parties who don't really want to enter into ADR but want to go and tick the box, they just do the cheap and cheerful method which the court can impose, and those who perhaps have a real intent to get some to get a resolution, they might actually do what people do now and agree an appropriate ADR forum, whether it's just a day mediation, wherever it might be. And you could see that happening. So you get the tick box at a very cheap price and very quickly, and then you all crack on to court, whereas the others are actually looking to choose the appropriate forum for them.
I know that we're going to have to open the floor to some questions, but just before we do, as a final thought, what about this then? And if Luke's is 2.0, I'll call my 2.001, which is maybe this, that the parties are mandated to agree to attend mediation or an equivalent. The two prerequisites are these. One, they must agree to it. Two, they can do it at any point, but it must be completed pre-trial. Robert, any thoughts on that?
Yeah, I mean, I guess that's not a million miles away from what I've been talking about in my system, I suppose. I think most of the problems that we've been discussing this afternoon get removed if the process isn't compulsory, which is effectively what we're all dancing around, I think, isn't it, really? I mean, all of the problems you've identified are all basically come down to circumstances where people have got no interest in using ADR, or they're committed to using it in a way which is part of a litigation tactic.
Which brings us full circle back, and then over to you.
Yeah, sorry to interrupt. We've had quite a few questions come through on this, which have now just disappeared on my screen. One of them was, if this is to be embraced, how does that affect without prejudice?
In terms of whether or not the judge can... I'm conscious that you can't ask a follow-up question. On the basis that is aimed at, if it's to be without prejudice, it's to sit on the other side of the curtain and no one can ever hear about it, not even the cost judge, then what that does do is that flies in the face of there being any ability to have any sanctions, because short of a cost sanction, it's, although Lady Justice Aspin did mention striking out POC or striking out a statement of case, it's difficult to see how a judge could ever strike out a statement of case if the arguments about impropriety sit on the other side of a curtain that the judge isn't allowed to look behind. Luke?
I think, as I said, there's one way of dealing with it, which is to say that the whole process will be without prejudice saves to costs right from the beginning. And perhaps you could have a halfway house and say that the parties were able to put in evidence on the question of sanction, but only if there was impropriety in the process or failure to engage. So you'd have to define exactly what that was, but there could be a narrow scope of evidence that you could put in and that could be admissible. And that would probably have to arise from the court making an order in advance saying that that's what it would do.
So I think our answer is we don't think the WP can survive in its pure format.
Great. Another question is, the judiciary is keen for lawyers to embrace DR, but clients will be liable for cost penalties for failure to use it. Might we see increased professional negligence claims?
Well, in the event that it's a compulsory step, then of course you're not furthering your client's interests unless you do comply with that compulsory step. It'll be another hurdle, such as maybe I shouldn't be describing a DRD or a Precedent H or a Precedent R as a hurdle, but of course we all think that they are. So if there's another hurdle, if the lawyer fails to meet that bar, then they've fallen beneath the standard. So it seems to me, I don't know what anybody else thinks, that yes, it's something else that you need to keep in mind and you need to make sure it's diarised.
And if it's pre-issue and you have to do it before issue, what's the impact on limitation? So that's not even being thought through either. So I think there are some very serious concerns for professional negligence claims, particularly if you've got a limitation problem coming up.
Okay, thank you. Another one. Given such antics have been discussed in arbitration, what opportunities would you see for an unwilling party to use guerrilla tactics to gum up a mediation?
Our tactics pessimist, Robert?
I'm struggling a little bit.
Well, in the event that somebody is trying to prolong the arbitration process, and this is just another tool in that arsenal, it seems to me, you can get the other side to spend more money by writing them 3 letters a day. I can't think of anything that's bespoke to arbitration unless somebody else can or somebody from the floor can. It'll be kicked into the long grass in the same way that litigation will be for those who want to kick that can.
Okay, thank you. And the last question that's come through on the automatic system is, might there be a benefit in a DR specialist being involved at the CMC in order to help establish whether DR might help, in brackets, with the benefit of private sessions?
Luke?
Yeah, I think it would be helpful. Just as, dare I say it, it's quite helpful to involve a cost specialist on cost budgeting and that sort of thing. I think it is quite helpful to bring in a DR specialist, not least to help the parties agree on the issues that are actually in dispute, because ultimately it's very difficult to find the roadmap towards resolving a dispute if you can't agree on the issues and you can't agree on the principles behind those issues.
I think if we've got some flexibility about what type of DR we use, then for me, the early neutral evaluation seems to me to be the most effective tool of all. And at what point you do that obviously will depend on the type of case and the framework, but at least then you're giving the parties an indication of what the outcome's likely to be. And that seems to me to assist in terms of cost and perhaps future direction of the case.
It would need to be with someone of authority, though.
Oh, yeah.
Hence, ENE usually has the judge or...
Yeah, and I'm talking about a judge-based sort of dispute resolution hearing or something. You could do that at the CMC, or you could do it earlier, depending on, again, there's got to be some flexibility over the framework because it depends on the individual case.
In my experience, there's quite a bit of reticence. I would have loved judges on a number of occasions to pick up on the point in a skeleton argument to say, on this point, I will give some sort of view or indicator at the CMC, quasi-ENE back, and now it's permitted in the practice direction. But thus far, the cupboard has been bare. I don't know whether anybody's got any experience of a judge saying, yes, fine, I'll give a view. Routinely, they seem to be saying to me, maybe it's just the way I put it, but routinely they say, no, that's for trial.
But this is encouraging this, isn't it? It's encouraging that more proactive management. Certainly the suggestion of judges taking a bigger role in dispute resolution does give that indication.
Yes, if they take the opportunity, yes, that'd be great.
Great, thank you very much. That's all we've got time for on this session. So thank you very much, Luke, Stephen, Sarah, Paul, for that.